Note 3. Acceptance and continuance of client relationship. Engagement partners should perform acceptance and continuance analysis to obtain such information that would be necessary to decide whether to accept an initial audit engagement or to continue an existing audit engagement with the client. Information may include the following: integrity of principal owners or top level management, competence and capability of engagement team members including availability of time and resources, compliance of ethical requirements including independence by engagement team members, significant matters that have arisen during current or previous audit engagement. Note 4. Assignment of engagement team. It is the responsibility of the engagement partner to ensure that the competent and capable team members are assigned the audit engagement so that overall audit can be performed in accordance with professional standards and legal and regulatory requirements. Note 5. Engagement performance. Engagement partner has the responsibility for direction, supervision and review so that audit engagement is performed in accordance with professional standards and legal and regulatory requirements. He is responsible for auditor's report being appropriate in the circumstances. It is the responsibility of the engagement partner to review the audit documentation before the audit report is issued. Engagement partner should ensure that sufficient and appropriate audit evidences has been obtained to support the conclusions reached and opinion issued in audit report. Engagement partner is also responsible for undertaking appropriate consultation on difficult or contentious matters. For example, he may consider the use of auditor's expert in case of certain pending litigations. In case of listed companies or certain other engagements for which a firm may determine that a quality control review is required, then for such engagements, engagement partner should consider the following. Determine that a quality control reviewer has been appointed. Engagement partner should discuss all the significant matters identified during the audit with the quality control reviewer. Engagement partners should not put date on the auditor's report until the completion of quality control review. If there is a difference of opinion between the engagement partner and the quality control reviewer, or within the engagement team or with those consulted by the auditor, then they should follow the firm's policies and procedures to resolve such differences of opinion. Note 6. Monitoring. Engagement partner should evaluate whether an effective system of quality control including monitoring process is designed and implemented to achieve objective of SF 220. Engagement partner should document the following matters regarding each audit engagement: issues identified regarding compliance with ethical requirements, conclusions reached regarding acceptance and continuance analysis, nature, scope and conclusions drawn by undertaking consultation, that is, using the work of expert during the audit, issues related to independence requirements if any. Ethics and terms of audit engagement, Chapter 11. Threats to independence. First, self-interest threats. These threats will occur when an audit firm, its partners or associates could benefit from financial interest either directly or indirectly in an audit line. Example: loan guarantee, contingent fees, potential employment, undue dependence on clients' fees, etc. Self-review threat. That was self-interest threat. This is self-review threat. These threats may occur when auditor is reviewing any judgment or conclusion which was drawn by auditor himself in the previous audit. Sometimes a member of audit team can be previously a director or senior employee of the client. In audit, if the audit firm has performed certain non-audit engagement, for example internal audit, investment advisory or any other management consultancy, then he should not audit the financial statements of same company since it will be a self-review threat. Third, advocacy threat. Advocacy threats occur when auditor promotes or is perceived to promote a client's opinion to a point where people may believe that objectivity is getting compromised. For example, when auditor deals with shares or securities of audited company or becomes client's advocate in litigation and third-party disputes. Familiarity threats. Familiarity threats are self-evident and occur when auditors form relationships with the client where they end up being too sympathetic to client's interest. This can occur in many ways: close relatives of audit team working in senior position in client company, former partner of audit firm being a director or senior employee of the client, long association between specific auditors and their specific client counterparts, and acceptance of significant gifts or hospitality from client's company, its director or employees. Provisions of Companies Act 2013 regarding rotation of auditors mainly address these very familiarity threats.